Start.
Dear friends, you are all aware that Industrial Employment Standing Orders Act governs the various relations between the employer and the workman. The only enactment which is of use to an employer while dealing with employees is the Industrial Employment Standing Orders Act. So far as IT and ITES industries are concerned, the government has exempted them from the applicability of this enactment. The exemption has been extended by a further period of 5 years, while notification dated 10/6/2024. While extending the exemption, the government in the notification has imposed 4 conditions. The first condition refers to establishing a sexual harassment committee as required under the Sexual Harassment Act. The second condition is that a grievance redressal committee should be put in place. This is a requirement under the Industrial Disputes Act also. The third condition is that any disciplinary action taken like suspension, discharge, termination, demotion, dismissal, etc. should be communicated to the Deputy Labour Commissioner or the Commissioner of Labour. The fourth condition is, if any clarification or information is sought from the ITES industry by the Deputy Labour Commissioner or Commissioner of Labour, the same should be immediately made available to the officers concerned. Now, there is a lot of apprehension in the IT industry with regard to the last 2 conditions. The exemption is granted under Section 14 of the Industrial Employment Standing Orders Act. Section 14 empowers the appropriate government by notification in the official gazette to exempt conditionally or unconditionally any industrial establishment or class of industrial establishment from all or any of the provisions of the Act. Now, the power to impose condition is conferred on the appropriate government by the Assembly, which has passed the legislation under Section 14 of the Act. So, the source of power for laying down conditions is Section 14 of the Standing Orders Act. Now, are these conditions highly objectionable, or could we call it as interference with the management of the company? These are questions. Merely saying that why should I answer is not going to serve the purpose in a socialist pattern of country like ours. The Department of Labour has been empowered to deal with all the industrial relations issues. In fact, the software engineers and those who work in ITES industry are all workmen as defined under Section 2(s) of the Industrial Disputes Act 1957. When all these employees are workmen, naturally the Department of Labour gets jurisdiction and authority to find out, to question as to what happens in these industries in respect of disciplinary action, punishment, etc. Particularly because they have been exempted from the applicability of the Standing Orders Act. So, no condition imposed under the Standing Orders Act would be applicable. Now, because the entire service rules is left to the IT industry, the government wants to keep a watch on how it is used by the industry. Therefore, it is not so easy or comfortable to go to the court and say, Why should I oblige? Why should I do this? Why should I do that? As long as you run the industry, the Labour Department and the provisions of law will have to be complied with. Therefore, I would suggest that these conditions, not being very complex or complicated, should be accepted and adhered by the industry. Thank you.